A very good day to everyone. My name is Xiaowen Jet, metric number 280289. I'm a member from Group 1, which our title for this assignment is The Ineffectiveness of Law to Eradicate Domestic Violence in Malaysia. Domestic violence is a pattern of abusive behavior. This behavior includes vandalism, threats, harassment, and mockery. All of these actions are exercised through the use of force, emotional harassment, or destructive verbal abuse. The World Health Organization estimates that 35% of women globally have suffered some kind of domestic abuse by an intimate partner in their lifetimes. Psychological abuse continues to be the most prevalent kind of domestic violence. It can be claimed that domestic violence is one of Malaysia's most severe societal issues, and eradicating the threat presents formidable difficulties. Domestic Violence Act 1994 protects women and every member of the family against acts of domestic violence. The latest amendment in 2017 introduced Emergency Protection Order, which can be issued within 2 hours. It prohibits the subject of order from engaging in domestic violence. The problem is whether the legislation as a whole in our country right now is providing adequate and effective protection to the victims of domestic violence.
So I'll be talking about the domestic violence law in Malaysia. To constitute domestic violence, it must be done by the offender, either via third party, spouse, ex-spouse, their kid, member of the family, member of their spouse or ex-family, and so on. So moving on to the section 3A of the DVA 1994, we have the Emergency Protection Order. Section 4, we have the Interim Protection Order. Section 5, we have the Protection Order, and these protection orders, it can forbid an offender from using domestic violence or encouraging another person to use domestic violence to the victim. So if the offender has breached the order, a fine of 2,000 ringgit to 5,000 ringgit or a sentence of 72 hours to 2 years in jail will be imposed. Whereas Section 10 allows the victim to claim compensation for bodily injuries and so on. Moving on to our court system, because we have magistrate court, we have session court, we have high court. So we could provide a domestic violence court as a one-stop solution for all the domestic violence victims in an earlier stage. Thank you.
Today I represent on the legal framework of domestic violence. There are a few legal frameworks governing the issues of domestic violence in Malaysia, namely the Domestic Violence Act, the Penal Code, and the Conventions on the Elimination of All Forms of Discriminations Against Women, and subsidiarily one guideline in combating the domestic abuse called the Garis Panduan Pengendalian Kes Kekerasan Rumah Tangga.
Today, madam, we will be elaborating on the intact issues and the challenges in domestic violence law in Malaysia, the deficiency from the perspective of law, and the hurdles that the women encountered. From the standpoint of the deficiency from the perspective of law, domestic violence is not a recognized crime. If the abuse is to be considered as an offense under the DVA 1994, the existing provisions of the Penal Code under Chapter 16 for offences against the human body must be invoked by the victims. Secondly, the legal enforcement of DVA 1994 maintains to place a greater emphasis on bodily harm than on non-physical forms of violence. Thirdly, the DVA 1994 doesn't recognize domestic abuse that happens between the unmarried couples. Fourthly, there is an urgent need to amend Section 11, subsection 1 of the DVA 1994, which regards counselling amid the case of domestic violence. Finally, it is imperative to examine the provisions in DVA 1994 with respect to protection orders.
Besides the weakness of law, there are also hurdles faced by the survivors of domestic violence. The first barrier is the cultural belief and values offered by the survivors. They believe their husband will change their behaviors if given a chance. Besides, the feeling of shame, self-blaming, financial dependency on abusers, and other traits makes them recoil when lodging the police reports. The second barrier is a religious understanding of the victim's influence and help-seeking behaviors. For example, Muslim women talk about the submission to faith, while Buddhism mentions about the karma. These beliefs have led them to submissions of the abuse. Thirdly, is the perception that domestic violence is a marital problem that needs to be solved between the couples and is best to overcome without involving third parties. Fourthly, lack of knowledge about the victim's right under the law can be another significant barrier. To make matters worse, court proceedings which are too formal and costly also hinders the victims to bring their case to the court of law.
Lastly, the efforts from all the parties are imperative to resolve the cases of domestic violence in Malaysia due to the ineffective way that the laws are implemented and the constraints experienced by women. Thank you.